السلام عليكم ورحمة الله وبركاته. المشاركون والحضور الكرام المتابعون.
Gentlemen, ارفع. It's my pleasure. Would like to welcome you to this lecture on the international humanitarian law between theory and practice in light of armed conflicts. Our institute works in the field of spreading knowledge. Before we start, please allow me first of all to introduce this lecture in collaboration with the Qatari Red Crescent and our institute, and specifically the program of human rights. It's my pleasure to give the floor now to my colleague Dr. Mu'taz Al-Fajari to deliver his welcoming remarks. Good morning, and we'd like to thank the Doha Institute and also the Center for Conflict Studies, and we'd like to welcome Professor Marco Sassòli, who will be speaking today on the international humanitarian law between theory and practice in light of armed conflicts. There is a wide-ranging interest in these issues and many issues which are on the agenda of human rights almost on daily basis. Every time we read a paper or to listen to a television program, we will be in touch with issues relating to the international humanitarian law and its applications, and especially in our part of the world where there is a complexity of local and international conflicts, and sometimes hybrid conflicts which are both of a local and international nature. The legal rights that is the subject of both debate and contention between states and non-state actors leads to the exacerbation of many conflicts that we see almost on daily basis. The program pertaining to human rights and the international humanitarian law is one of the programs which we have established at our institute right from the beginning, and the studies and the issues relating to the international humanitarian law is in close association with human rights and the armed conflicts and other. And of course, this is related to other programs that we have. It's important to decimate knowledge of the content of the international humanitarian law in our area and the challenges faced by the application and implementation of the international humanitarian law and the gray areas. We can talk about this issue at the theoretical level is one thing, but when it's applied in reality, on the ground, it takes different complexion altogether. Also, amongst the basic issues dealt with today will be the legal jurisdiction, both at the local and international, universal level, and the role of the international organizations and the issues pertaining to accountability and justice and transitional justice, dispute resolution, and many other issues. I do not want to take too much of your time. I would like to thank Dr. Ghassan, and now I give the floor directly to Professor Sassoli. Dr. Ghassan, I do not want to take too much of your time because we want to give all the time to the professor. He is a well-known person. He doesn't need many introductions amongst the internationally renowned thinkers and intellectuals. Professor Marco Sassoli is a professor at Geneva University, and also he is a special advisor to Professor Sassoli has many publications in the field of international humanitarian law and other issues relating to it, like responsibility of states and other parties. Professor Sassoli held many positions, including the chairmanship of the Geneva Academy, and he was head of the international law at Geneva University. And from 1995 to 1997, Professor Sassoli worked for the International Committee of the Red Cross, and especially the legal department, and also he worked in Jordan and Egypt and other countries in the former Yugoslavia. And we have lately signed a memorandum of understanding with the current institute that he works for. Professor Sassoli will present for 45 minutes. Then after that, there'll be a questions and answers, and chaired by Dr. Iyad Nasr. Then in the last few minutes will be given to the Qatari Red Crescent, and this lecture will be live streamed on the social media, and we have simultaneous interpretation between English and Arabic. You can take part later on through the chat feature, or pose your questions directly. Now I give the floor to Dr. Iyad. Thank you very much, Dr. Ghassan, and thank you, Dr. Mu'taz, and thank you to the Red Crescent, Qatari Red Crescent. It's my pleasure to welcome Dr. Marco Sassoli, our guest today here in Doha. What I want to talk about is, why was this invitation sent? We think international humanitarian law is not something exclusive to people in the legal profession, but it has intersections with other fields of knowledge and practice. Therefore, it was important for us to disseminate knowledge, to introduce this law, and to encourage our students and researchers to be aware of the applications, especially when it comes to dispute settlement and studying the humanitarian conditions, especially what we see in this country specifically, and the role of mediation Qatar plays. دكتور ماركو، أود أن أعطيك الكلمة لكي تقدم لنا محاضرتك. بعد ذلك سنفتح الباب أمام الأسئلة والأجوبة. إذا تفضل مشكورا.
Salam alaikum, ahlan was ahlan, and thank you very much to the Qatar Center for Humanitarian and Conflict Studies, and to the Qatari Red Crescent to have organized this on international humanitarian law. I know that most of you know very well humanitarian law. Nevertheless, very shortly, a reminder that this law applies only to armed conflicts, and it is part of international law, public international law, and it shares all the weaknesses of public international law. There is no world government, there is no world police, and nearly all of us would not like to have a world government and a world police, and therefore we shouldn't be astonished that this law is not enforced like domestic laws. And then the term humanitarian law is also somehow dangerous, because it gives the impression that these rules are humanitarian. Humanitarian law can only try to offer a minimum of humanity in a profoundly inhumane situation, which is an armed conflict. And I think, and this is sometimes forgotten, including by people engaged in humanitarian studies, that the main aim is not to make war. And if there is war, it will never be humane, even if humanitarian law is respected, but it can be a little less inhumane for some people affected by the armed conflict. Humanitarian law protects those who do not or no longer directly participate in hostilities, the civilians, those who surrender and become prisoners of war, and the wounded and sick. And it limits the amount of violence to what is inevitable to weaken the military potential of the enemy. And for that, it is not necessary to destroy the whole enemy country. And humanitarian law protects people in the power of the enemy. Here we have the 4 Geneva Conventions, the first on the wounded and sick on land, the second on wounded and sick and shipwrecked on sea, the third on prisoners of war, and the fourth on civilians essentially in the power of the enemy. But humanitarian law also applies to the conduct of hostilities, protecting people who are not in the power of the enemy, but who are bombed, for instance, by the enemy. We have these rules on targeting and the conduct of hostilities in additional Protocol 1, and most, but not all, rules of additional Protocol 1 are customary international law, which applies both to international and non-international armed conflicts. Now, I was asked to speak about the challenges, and the first challenge is a traditional challenge. You need to classify the situation. For human rights law, you don't need that. Human rights law applies always. Humanitarian law applies only to armed conflicts. And some states deny that there's an armed conflict to escape from humanitarian law, and other states claim that there is an armed conflict where there is no armed conflict to benefit from the greater latitude which exists, in particular when it comes to the use of force and to the possibility to detain enemies if there is an armed conflict. And within armed conflicts, we have to distinguish international and non-international armed conflicts. So, to give 3 examples to this classification, The armed conflict between Russia and Ukraine is an international armed conflict between two states, and humanitarian law is best developed in the treaties for such conflicts. In Yemen, we have a non-international armed conflict, although many states are involved, several states are involved in that conflict, but the legal reason why it's not of an international character, it's just a question of 2 weeks. When President Hadi called for the Saudi-led coalition to intervene, he was still the president of Yemen. And so now the third states which intervened in Yemen are engaged in a non-international armed conflict against, in particular, the Houthi rebels. This could be an international armed conflict if the Houthi rebels were under overall control of Iran, but I think that this cannot be said, that Iran actually directs the operations of the Houthi rebels. And finally, I don't dare to say good news, but also there are armed conflicts which end. And Afghanistan, the humanitarian problems continue, but the armed conflict has, in my view, ended. Also, humanitarian law has some rules which continue to apply even after the end of the conflict, like on the search of missing persons. Now, often it is very difficult to classify a situation. Think about Gaza, fighting between Hamas and Israel, but Hamas is a resistance movement, perhaps of Palestine, but the Palestinian Authority is not clear about Hamas. So it creates all kinds of problems, including when a state declares its independence and is not yet recognized, and then it's very delicate to decide whether this is an international or a non-international armed conflict. The good news is that it is not so important to classify, because today the rules applicable in international and in non-international armed conflicts are considered to become more and more similar. Nevertheless, there remain differences, and one important difference is combatant status. Only in international armed conflicts, people who fight for their state and get captured by the enemy benefit from combatant immunity, which means they cannot be punished for having participated in the conflict, and they become prisoners of war with all the rights foreseen by the Third Geneva Convention. Second, occupied territories. The best protection to civilians, at least in law, because Palestinians would say, in fact, is for civilians in occupied territories, but you cannot have occupied territories in a non-international armed conflict, because no one could determine whether the government occupies the rebel-controlled areas or the rebel control government. They all fight for the same country. And I think we should not forget that the law of non-international armed conflict is addressed also to armed non-state actors, and armed groups have less capacity to comply with sophisticated rules. So I'm, and this is a minority opinion, one of the few who considers, let us not develop the law of non-international armed conflicts too far to get it similar to the law of international armed conflict, because most rebel groups simply do not have the capacity to implement too sophisticated rules. And finally, an important difference remains that the ICRC, the International Committee of the Red Cross, has a right to visit protected civilians and prisoners of war in international armed conflicts, while in non-international armed conflict, it may only offer its services, and therefore, if it is denied access, this is not a violation of international humanitarian law. Now, all this presupposes that there is an armed conflict, but very often there is controversy whether we have an armed conflict or we don't have an armed conflict. Here, too, we are not totally lost because of international human rights law. And humanitarian law and human rights law are not so different. Also, obviously, for exams for law students, you want to test them whether they understand the difference. But in reality, to torture, to deprive people of food, to deliberately kill people, to rape, all this is prohibited by both human rights law and humanitarian law. And in particular in non-international armed conflicts, where the rules of humanitarian law are less developed, often, obviously, we can nevertheless find a solution in international human rights law. In particular, if we do not make analogies with the law of international armed conflict, you know. The humanitarians started to want to make such analogies because they said, we have a lot of rules for international armed conflicts, and so we import them into non-international armed conflict. And then President George W. Bush said, yes, let us import, but we will detain enemies in a non-international armed conflict as if they were prisoners of war. We don't give them the privileges, but we don't have to give them a trial, like prisoners of war. And Bush, Obama, and all considered that in an international armed conflict, and this is correct, it would have been in the Second World War. If the United States killed Japanese generals with a drone, we would all have applauded because we want to have targeted killings and not indiscriminate attacks. I always shock my students in Geneva when I say, we want to have targeted killings. But indeed, this is the message of humanitarian law in international armed conflict. It must be targeted and not indiscriminate. Now, if you import this into a non-international armed conflict, then you have drone attacks against so-called unlawful combatants. And if in this room there was one unlawful combatant, we would perhaps be incidental victims of a lawful attack by a drone. And the difference is, if there was a Japanese general in this room and there was an armed conflict between Japan and the United States, we would know it's dangerous to be near the general because he is a legitimate target. Now, also there is the right of initiative of the ICRC and impartial humanitarian organizations, which is clearly laid down in Article 3 common to the Geneva Conventions, at least as soon as we have an armed conflict. This is much more complicated without an armed conflict. And a good example is the situation now in Afghanistan. In an armed conflict, it is, in my view, a violation of humanitarian law if a state considers that to for a humanitarian organization to offer its humanitarian services to an armed group, even if the armed group is labeled as terrorist, is a crime of supporting terrorism. And I had to make a big fight in the Swiss parliament, but I won and the government lost. That we have an exception now in the Swiss criminal law, and only Chad has also such an exception, saying that the criminalization of support to terrorism, there's an exception for impartial humanitarian bodies offering their services to a party to an armed conflict, whether this is labeled as terrorist or not. And this obviously outside armed conflict, and this is the problem now. In Afghanistan, there is no such rule. And therefore, it can be criminalized to negotiate, to support a government, a group, and so on, even if it is only for humanitarian purposes. Now, nevertheless, it makes a difference whether humanitarian law applies or not. First, there are controversies about human rights law, whether it applies extraterritorially, so whether Saudi Arabia has to respect human rights law in Yemen, and whether armed non-state actors have to comply with human rights law. Traditionally, human rights are directed to states. When it comes to war crimes, for war crimes you need a war. And there are no war crimes without a war. And therefore, if there's no armed conflict, there are no war crimes. Then, as soon as we do not, in humanitarian law, and I come back to that, it is very difficult to defend, but nevertheless essential, the equality of the parties before humanitarian law. Obviously, outside humanitarian law, there's no equality between criminals and the government. And the second big challenge, which I have very much experienced in recent times concerning the conflict between Russia and Ukraine, is the difficult separation between jus ad bellum, the haq al-harb, and jus in bello, the kanun in harb. And international humanitarian law is part of the kanun al-harb. And it is essential to keep the two separate. And the fact that Russia is the aggressor in Ukraine, and I think I have no doubt about that, does not mean that necessarily Ukraine does not violate humanitarian law and that Russia, everything they do, violates humanitarian law. But believe me, this is a difficult message to go through. I said once in the Swiss radio, as long as Ukrainians defend every house in Mariupol, Russians may attack every house in Mariupol, which is correct in IHL, and every student who says it is incorrect fails the exam. Nevertheless, I got a shitstorm in the social media because they said, how can he criticize the Ukrainians who only defend themselves? Well, this is the separation between jus ad bellum and jus in bello. And this was always difficult for the parties to the conflict. You know, I started dealing with IHL, with the ICRC in the long time ago, I'm old, in the armed conflict between Iran and Iraq. And I was based in Iran. And the Iranians said, we love humanitarian law, and it is fully in conformity with the prescriptions of Islam. But you know, Saddam Hussein attacked us. And they are right. Today we can say it. At the time, no one in the Western world said it. But Saddam Hussein was the aggressor in that war. But this is not a reason why the Iranians don't have to comply with IHL. And you know, I was not popular when I told them, you know, I don't care who was the aggressor. You have to treat the Iraqi prisoners of war correctly. Because no one appreciates, you should hear my Ukrainian student, I have only one. But each time she gets a heart attack when I criticize Ukraine, and there are things to be criticized about Ukraine. For instance, that the so-called country which defends Western values still gives no access to the ICSC to all Russian prisoners of war. This is classical. In every armed conflict, don't try to convince the Palestinians that they have the same obligations than the Israelis. But it is essential. And now what is special in the war in Ukraine is at least the whole Western world is in the same situation that it also always mixes jus ad bellum and jus in bello, and no one dares to criticize Ukraine. Also, there are things to be criticized. And every single attack by Russia is seen as a violation of humanitarian law, which is not true, because obviously, I mean, there are military targets, there are important military targets in Ukraine. And a side effect of this is that impartial humanitarian action, the neutrality of impartial humanitarian action, is difficult to get accepted. Some of you may know when the president of the ICSC traveled to Moscow and shake hand with Foreign Minister Lavrov, he got a shitstorm in the social media. How can he dare? But I mean, this is his task. He must speak with Lavrov, because how do you want to protect Ukrainian prisoners of war if you don't speak with the people who are responsible? And I have worked 13 years with the ICSC, and I am proud that I fortunately discussed most of the time with war criminals, because the definition of a war criminal is a person who has an impact on the reality on the ground. And it is important to discuss with them humanitarian matters. Then another challenge is obviously, but here we try to overcome it, thanks to all of you, the misunderstanding of humanitarian law. A lot of people expect too much about humanitarian law. They think every time someone is killed in an armed conflict, this is a violation of humanitarian law. But this is not the case. And every house destroyed is a violation. No, perhaps it was a military objective, or it was a mistake, or it was a proportionate attack against a legitimate target. And a challenge is that states do not want to adopt new rules. Since 1977, there has been no general update of humanitarian law. And there are some soft law instruments, you know, all kind of manuals and declarations, but they are produced in a very non-transparent way, and no one knows exactly who is behind, and then suddenly we are told this is the new law. And obviously customary law is today very much en vogue. To say what we couldn't get through treaties, we claim this is customary law, but you know, custom. I wrote my doctoral thesis about customary law. Custom had something to do with the reality, and the reality is not very humanitarian, and not much more humanitarian than the treaty rules. And as I mentioned, the fight against terrorism is also a challenge for international humanitarian law, both because nearly every party, non-state party to an armed conflict is labeled by the government as terrorist. while when we have an armed conflict, we should deal with it under the title of humanitarian law, and sometimes they commit war crimes and they have to be punished, and some acts, like killing soldiers, are not a violation of humanitarian law, even in a non-international armed conflict. And I also already mentioned that serious problem for all humanitarian organizations of criminalizing humanitarian assistance by saying this is support to terrorism. But obviously, if you want to help people who are in Gaza, you have to discuss with Hamas. You cannot do it otherwise. And as I said, I think if you criminalize this, this is a violation of Article 3 common to the Geneva Conventions, because Article 3 common says that an impartial humanitarian body has the right to offer its services, and if international law says you have a right, then a state may not criminalize those who exercise this right. And finally, sorry, so many challenges, double standards. And this undermines very strongly the credibility of humanitarian law. First of all, double standards by nearly everyone. You know, humanitarian law is not about protecting your friends, but it is protecting your enemies. So ideally, I always said, and I got neither sympathy from my Israeli nor from my Palestinian friends when I said dissemination of humanitarian law in Israel is about how to respect the Palestinians, and in Palestine it's about how to respect the Israelis. This is not a popular message nowhere where there is an armed conflict. Everyone has double standards, every one of us. Considering that those people we like, they may commit violations of humanitarian law, but these people we don't like, they may not. And the effects of the double standards are that they undermine the credibility of international humanitarian law, and they provide an alibi to those who want to violate it. One of my preferred examples, and I have the great chance to be a professor and therefore to be able to give always examples. While when I worked for the ICRC, I could never give examples. And one of my examples is, which I think is correct, that the International Criminal Court issued an arrest warrant against the former Sudanese president Omar al-Bashir. And he killed plenty of Sudanese civilians. But my experience in both Lebanon and Palestine is that a lot of young students had a sympathy with Omar al-Bashir. Why did they have them? Not because they like people who kill Sudanese, but because they said, why is there an arrest warrant against Omar al-Bashir and not against Netanyahu and so on? And this undermines the credibility of humanitarian law and gives an alibi to Omar al-Bashir to say, look, I continue to do what I want to do because anyway, they don't do it with the others. But this, and now we become a little more optimistic, this is also a great chance for progress, because the rules which are today claimed to be violated by Russia in Ukraine will have to be respected in the future by those criticizing Russia. You know, the NATO Secretary General, and I'm with him, criticized the use of cluster bombs by Russia in Ukraine. I'm happy, because next time the US or Israel use cluster bombs, we have a precedent. We will call the NATO Secretary General and we will tell him, look, now do something. And, you know, that everyone is equal before the law is an important message of the law. And therefore, if today you say X violates, next time you will be criticized if you violate it. Now, when it comes to the respect, I think there is quite some progress in prevention. There is an increasing interest. I mean, I'm very honored. You didn't come because of me. You came because you are interested in international humanitarian law. There is increasing dissemination in universities, teaching of international humanitarian law. You know, I sound like a dinosaur when I tell you that I come from a university which in the 1960s was the only civilian university in the world which was teaching humanitarian law. Today we have nearly 1,000, and this is big progress. And in the UN, there's much more discussion about humanitarian law, and the human rights mechanisms take increasingly into account humanitarian law, including human rights NGOs. Okay, sometimes they get it wrong, or they are very militant and therefore criticize something which is not nice, but not a violation of humanitarian law, but nevertheless. And the breathtaking development of international criminal justice, not only, this is marginal, in the International Criminal Court, but also on the domestic level, in an increasing number of countries, war criminals are prosecuted, including based on universal jurisdiction. Nevertheless, there are also challenges, and I think the greatest challenge is the erroneous impression that IHL is always violated. Because obviously, the media, the NGOs, but also international commissions of inquiry. You know, I was involved in the first OSCE mission of inquiry into the violations of humanitarian law and human rights in the conflict in Ukraine. And I managed that we mentioned in 2 instances that there is also a lot of respect of IHL. But obviously, 95% of our report is about violations of IHL by both parties. This is inevitable. And I don't criticize the media. Sorry if there's someone from media here. I don't criticize you because it is logical that you report about what is not working. You will not report that yesterday 100,000 drivers were correctly driving through Doha. But if one driver was driving 150 an hour, the newspaper will report about it. Okay. And the only chance to get the amount of respect is when you are in the field. You know, I worked in Gaza, I worked in Iran, Iraq, I worked in Bosnia, and everywhere I have encountered violations, but also a lot of respect of humanitarian law. And why is this so dangerous? Because if public opinion has the impression that humanitarian law is never respected, no one wants to respect it. I mean, why should we respect something which is not respected by anyone? And it is true that we need stronger enforcement mechanisms, but states don't want that. The International Committee of the Red Cross and Switzerland have suggested very weak, but nevertheless progress, a meeting of state parties about the respect of humanitarian law, because you know, in nearly all other treaties we have meetings of state parties. In IHL we don't have that. States did not find a consensus on that, so we don't have it. And obviously you will say, yes, but we have the International Committee of the Red Cross. Now, I'm a fan of the ICSC, although I'm not neutral because I worked for 13 years for them. But we have to be conscious that the ICSC as a humanitarian organization will always give priority to access and to help the victims, and therefore will not criticize violations. Don't expect the ICSC to criticize neither Russia nor Ukraine. And this, if even the guardian of humanitarian law will not invoke humanitarian law, this weakens humanitarian law, because then no one invokes humanitarian law. Now the United Nations, they have made progress, but inevitably first there are double standards. I mean, until 2 years ago, I was able to say, it is wonderful, no, we shouldn't have an armed conflict, but each time a new armed conflict breaks out, there's a commission of inquiry, be it on Gaza, on Central African Republic, on Libya, on South Sudan, everywhere. And then the commission of inquiry on Yemen was stopped by Saudi Arabia. It got a majority in the Human Rights Council. And so there are double standards. And the Security Council, which has in some instances done a great job for humanitarian law, is now blocked because of the war in Ukraine. And therefore, also on theoretical issues, on general issues, some progress can still be made. Don't count on them to stop violations. Finally, the international criminal justice, I think it's very important to punish war crimes, but please don't have the wrong impression. I get all the media calling me, is this a war crime by Russia? And I tell them, Russia cannot commit war crimes. Only individuals can commit war crimes. And it is very difficult to find the individual who is responsible. But the media are not interested in violations of humanitarian law by a party, but in war crimes. And war crimes, because, and I'm in favor of judicial guarantees, you have to have the evidence as a prosecutor that this person is the one who bombed deliberately civilians. And again, international criminal justice has no police. I mean, yesterday we had a very interesting discussion, and some people asked me, and why does no one arrest X, Y, Z? Well, the Qatari prosecutor, when he considers that a crime has been committed, sends the police and the person is arrested. And if you are a witness, you have to testify. International criminal justice, very difficult. And also national criminal justice when it comes to universal jurisdiction. If you want to make in Switzerland a war crimes trial against someone who committed a crime in Algeria, well, it's a very difficult thing, because Algeria will not cooperate, and the person, the witnesses are in Algeria, and so on. Okay, I see that I should finish soon. Obviously, there are particular difficulties to obtain respect in asymmetric warfare, because there's no reciprocity, the positive reciprocity. You know, if it is asymmetric, I respect because I hope that you respect. But in an asymmetric conflict, only one side bombs, and only one side commits suicide attacks. And so there is not the incitement to say, let's not do that, because otherwise they do it too. And we could make a whole seminar about the difficulties to engage armed groups. Armed groups are bound by humanitarian law. Article 3, common to the Geneva Convention, says explicitly that the parties, plural, capital P, 1949, capital P, to the conflict have to comply with the following rules, and then comes the list of the rules. But international law and its implementation mechanisms are still very state-focused. And it is difficult to engage armed groups to respect humanitarian law because you have, first of all, let them know humanitarian law, and second, to convince them that humanitarian law, also it has been made by states, is not necessarily biased against states. I would even say, but there I become an exotic extraterrestrian, that armed groups should be involved in the development of the law of non-international armed conflicts. You know, if we want to make a new law of naval warfare, we would certainly consult the world's navies to understand what are their problems and what are their possibilities. And therefore, if we want to develop the law of non-international armed conflicts, we have to listen to armed groups. And most armed groups are considered as terrorists, and therefore we cannot invite them. And here there is an NGO in Geneva, Geneva Call, which tries to do that, and somehow miraculously Switzerland allows all these terrorists to come to Geneva and to meet Geneva Call and to undertake a commitment, because the start, I know this as a grandfather of the daughter of my daughter, the first thing I need is that she promises to do something. I cannot tell her, look, the rule is you must promise. And when she promises, then I can say, why didn't you keep your promise? And so the armed groups undertake a deed of commitment where they promise to respect certain rules of humanitarian law, and then you have to check whether they actually do it. And obviously, it's not easy to disseminate, to train armed groups in IHL. You know, I was once invited in Peru to give a conference on engaging armed groups. And they made a mistake in translating the title, because they put as a title, Cómo reclutar a grupos armados, how to recruit armed groups. And they said, we don't need people who recruit armed groups. But underlying, there's an important point, that if I train an armed group how to target precisely, not indiscriminately, this is support to the armed group. And I understand the government who says, I don't want to Sassòli to explain how to target soldiers, or even how to organize a trial, because no government wants to have rebels organizing trials. But it is essential, if you have an armed group, like the Kurdish groups in northern Syria, they have so many detainees, and they must organize trials, because these people cannot for 10 years be detained without any procedure. And we would need incentives, somehow to make a difference, whether they comply with IHL or not. And this is a big difference between international and non-international armed conflict, because in an international armed conflict, if I'm a soldier who complies with IHL, I become a prisoner of war, and I will be repatriated at the end of the conflict. While if I don't comply, I'm still a prisoner of war, but I may and must be tried for a war crime, and I will not be repatriated, but I remain in prison until I have served my sentence. So I have an interest to comply with humanitarian law, while this is not the case in non-international armed conflicts. I give also, I live in a little village near Geneva, and I say, if I found a Lancy, and if I found a little movement, free Lancy movement, and I fight against the Swiss government, even if we comply with IHL, if we kill Swiss soldiers, which would be very bad for me because my son is a Swiss soldier, they would punish me for murder. That's the big difference in between international and non-international armed conflict. So this is a different. And we should make sure to make IHL realistic for armed groups. And I could give you, if we want to have that in the discussion, plenty of rules where I have some doubts whether it's realistic. And unrealistic rules don't protect anyone. But how can we make it realistic? Well, asking armed groups, what is the realistic solution to this humanitarian problem? So we have to speak with them, and therefore I'm very much in favor of all the initiatives of Qatar to have a dialogue with all kinds of groups you don't like, I don't like, but we have to speak with them to understand them. And I don't think such discussions support terrorism. So the opportunities, and I will finish with this, there's an unprecedented willingness of third states to ensure respect for IHL in Ukraine. Never. There has been so much commitment to IHL. Now we have only to get it that this is applied everywhere. Think about Ethiopia. I don't speak about the region. Ethiopia, 10 times more civilians have been killed last year in Ethiopia than in Ukraine. Who cares about Ethiopia? Obviously, there is a difference in jus ad bellum. Ethiopia didn't attack any other neighboring state while Russia attacked. But if we stay in IHL, there are differences, I spoke about them, between IHL of international and non-international armed conflict, but somehow they are marginal, and they cannot justify the difference between 10 times more people, civilians, killed. And therefore more attention must be brought, but it's the first step. Somehow public conscience has been woken up by the conflict in Ukraine, and there is an unprecedented willingness to fight impunity. The prosecutor of the International Criminal Court is inquiring since 10 years on Palestine, and nothing has yet come out, while his teams, after 2 weeks, were already in Ukraine. And on Afghanistan, we have similar things. And also domestic courts have prosecutors in a lot of European countries have now formed task forces on war crimes. And the media said, for instance, the Swiss fraud, the federal prosecutor has formed a task force on Ukraine, and I met him because I studied with him, and he said, no, don't be afraid. We deal with all the war crimes everywhere in the world if the suspect is in Switzerland. But simply the media wanted to speak about it in Ukraine, and this is how it should work in a sense. And therefore it's a first step. If they get conscious that they need legislation to apply universal jurisdiction for Ukraine, then they have it for every other context. And finally, I have published an article in the International Review of the Red Cross with some I was astonished that they published it, very nonconformist ideas to say, perhaps we should agree, as we have an international labor law, on some fundamental standards of humanitarian law, and then each state declares, but publicly, sorry, and the military don't like that, the word publicly, all the rest they like. How they will interpret these fundamental standards in their actual operations, but this is not a good solution. It's simply a better solution than to have nothing. And indeed, in recent years, we didn't have any development of humanitarian law, and on many issues, we would nevertheless need some developments. Well, I was already too long. Sorry for that. Thank you so much, and I'm at your disposal for any question or criticism. Don't hesitate to tell me that I'm on the wrong way. Thank you.
Well, thank you very, very much, Dr. Sassòli, for the insightful speech and presentation. This is very remarkable where you have taken us in this journey from introducing the IHL, its different components, its differences and similarities with the human rights law, but also you've taken us to some international relations, the role of the states, the role of the media in terms of interacting with the IHL, some remarks on also the role armed groups need to play, or the roles that they should be given, what kind of need or the need we have to adopt, to talk and to have the dialogue with these groups if we would like to have a more respectful relationship with states in this regard. I think also the analogy that you have brought about the differences and similarities nowadays between the international armed conflict and non-international armed conflict is essential, and the differences about the ICRC position, the role or the status of the combatants and fighters inside that, the difference between the right to the law, the right to war, and the law of war. All of these are of a great help and use for us. So without further ado, if you don't mind, Dr. Sassòli, we'll give the floor to our audience. If there are points of clarification, comments, or questions to be asked, we would love to present them to you for a detailed answer as much as the time allows. So, colleagues, I would give you the floor if there are remarks or questions you would like to present to Dr. Sassòli, where we'll be able to answer them to yourselves. So, colleagues. Dr. Khalil, if we have the mic here, please.
Dr. Sassòli, thank you very much. I'm Khalil Othman from the Center for Conflict and International Studies. This is a fascinating presentation, and I would like to point out that I share some of the concerns that you raised regarding how to deal with non-state armed actors. I have worked for many, many years in conflict areas where I had to deal with non-state armed actors. But then when it comes to the issues that you raised, I mean, you kind of opened a can of worms for us. You pointed out on the one hand that these non-state armed actors do not have the capacity to implement international humanitarian law, which could be understood that you are creating a kind of a duality, that we don't expect them to begin with to apply international humanitarian law. And then we run the risk of creating a sort of a duality that is at odds with the universality of international law in general. Then on the other hand, for practical reasons, we would need to involve them even in the development of rules. And I would like to take the question that, or the example that you presented. We would involve navies for issues dealing with maritime international humanitarian law. But would you really want to involve the pirates in Somalia when it comes to developing international humanitarian law, dealing, I don't know, with fisheries and issues like that? Or how would you involve someone on the protection of civilians if they come from a non-state armed actor whose very strategy is based on targeting civilians? Thank you very much.
Doctor, you'd like to answer? Go
Yeah.
ahead.
Let's have it.
No, come, take this one. Take this one.
Okay. No, thank you. Okay. So, yes, I understand your doubts, and I have them too. I should clarify it is not about capacity to respect Article 3 Common of the Geneva Conventions, and in my view, even not Protocol Additional 2. But there's a large tendency today to say, which is honorable, to say the law of international and of non-international armed conflict is the same. And here I would caution, don't go too far. Think about the capacity. I give you just one example. The ICSE customary law study says that arbitrary detention is prohibited in international and in non-international armed conflicts. And it defines arbitrary detention in conformity with human rights law as a detention without a legal basis and without the possibility to challenge the lawfulness of the detention. Now, some armed groups are able to legislate and to have a habeas corpus, an amparo procedure, but they are very few. Most of them simply do not have the capacity, and it will only be a show. And we don't need a show. And the show is contrary to human rights law because we don't want a show. And so I agree with this duality of obligations issue, which is dangerous. But then let's lower the obligations, but say, but this you must do. And then also the government has lower obligations, but the government has also human rights obligations. And the human rights obligations are higher. While in IHL, you would have on both sides the same. And now involve navies and pirates. Well, I think this is the big difference between crime and armed conflict, and therefore it's so important to distinguish armed conflicts. As soon as there is an armed conflict, they become actors, and we have to listen to them. I don't say we have to do what they want us to do, but I mean, if states, and they sometimes commit piracy, and you know in the history, both the Christian and the Muslim states committed acts of piracy in the Mediterranean, and then we have to speak with them about what are the rules applicable. And you know, piracy is what a criminal does. While when states do the same thing, there are technical words in the law of naval warfare, like confiscation, visiting a ship, and prize court, and all these old-fashioned things. So what I simply say is, let's listen to them. I don't say, and then we have to do what they tell us, but we have to understand their problem. And then we have to find a rule which is both humanitarian and it deals with their problem. And now your argument, and I understand you, the so-called Islamic State, when they burned a Jordanian pilot alive, I also said, okay, what can we do now? Because they don't hide it, you know? Many other armed groups commit plenty of violations, but they don't make propaganda with their violations, while the so-called Islamic State made propaganda and recruited other fighters with their violations. Okay, but here again I would say yes, but states also violate humanitarian law, and we don't say, okay, we have no more dialogue with them. And look, the International Committee of the Red Cross has been, in my view, rightly criticized that it did not speak to Nazi Germany about the concentration camps and the treatment of the people in the concentration camps. But somehow, has anyone the illusion that Hitler would have said, if the ICSC says, look, why do you do that? Okay, somehow the Jews are nice people, and why do I try to kill them? No. So, nevertheless, everyone expects today, retroactively, that the ICSC would have tried to have a dialogue. So we have to try. This is what I always said when I was chairing the board of Geneva Call, because I have to make a coming out that I'm not a neutral person on Geneva Call. I chaired its board for 9 years. Now I'm no longer involved with it. But okay, to say we have to try, and if they don't want to have a humanitarian dialogue, okay, but at least we have to try. And it's not me. It's the UN Secretary General who wrote in one of his reports about the protection of the civilian population that armed groups are not monoliths. You always find some people within an armed group who understand that they better have a dialogue on humanitarian matters, because they will not win if they ignore totally the humanitarian matters, because also the population, the sympathy they need from, they will lose this sympathy. And you have to work with these people, as the Secretary General wrote, to get advocates within the armed groups. But you know, basically I agree with you, it is difficult. But I mean, with your experience, you will certainly agree with me, we have to try. We have always to try. And if it doesn't work, okay, but at least we tried. And in some cases, we get something. And I must say, Geneva Call got some deeds of commitment and some respect of those deeds, even from groups which are considered as terrorists by at least all the Western states.
Thank you, Dr. Sassòli, for the comprehensive answer. Let me take one of the questions that came to us through social media from Mr. Kamal Dahmani. Mr. Kamal Dahmani is asking about how can the law protect the non-state armed carriers while they are not recognized internationally? And also is asking about the smart or intelligent weapons in IHL, if you don't mind.
Well, these are two very important questions. The first one is the dilemma I mentioned, that there is no combatant status in non-international armed conflict. So IHL protects members of armed groups who fall into the power of the state against torture, against summary execution, against unfair trials. But they may be tried and they may be sentenced for what they did, including if they did not violate humanitarian law, because they used violence, and no state can tolerate that violence is used between citizens or between a citizen and the state. So, but there are some protections, which is, yes, humane treatment, and they may be able to inform their families that they get food in their prison, that they are not executed, but they get a trial, and so on. And now artificial intelligence, this is a big channel. This is a big challenge to IHL, and some people say, and this is a good debate, and we should have some theologists here, because some people say, no, it must be only human beings can decide to kill another human being. Well, I'm slightly shocked by the idea that one human being decides to kill another human being. And IHL, these are more objective criteria, whether someone is a legitimate target, and it does not correspond even today. I mean, if I send a missile as a soldier 10,000 kilometers or 1,000, I don't decide this human being, I want to kill him. Hopefully, the missile is only directed against a military objective, but I don't know the human beings who will be killed. But hopefully, I checked that these are combatants. So I wonder, but we can have a very interesting discussion about this, whether artificial intelligence could not also help to better respect IHL. Because, but you know, everyone is marked by his history. And my history is I experienced people in Bosnia and elsewhere who didn't comply with the rules, although they knew the rules. While in artificial intelligence, if you correctly program the computer will normally not suddenly hate or be tired or, okay, there can be technical failures, but all of us having a car knows that we make more mistakes than our car. So, sorry for this very politically incorrect plaidoyer in favor of give artificial intelligence a chance.
Thank you, Doctor. Please.
Thank you so much, Dr. Sassòli. I'm Yazid Amr from the Human Rights Program. My question, I actually have two questions. First of all, the world wars gave us the UN, or the human rights as it is right now, and its developments. And it seems that the IHL only develops when there's also certain amounts of war and turmoil. Do you think that we need, in this context, of course, more wars to develop IHL? And the other part is figurative, or let's say, what rule would you add? What have you seen in our conflicts that does need a new rule in the IHL? Thank you.
Thank you so much. I mean, I have still hope that the civilization makes progress, and therefore we don't need first a war to see where the problems are. And there is some hope. I mean, blinding laser weapons have been prohibited before they were ever used. So it was not, because your description is historically absolutely correct, that for most rules this is true. First a problem arose, and then rules, and perhaps the war in Ukraine with all its tragedy, for instance, for the use of explosive weapons with a wide area effect in densely populated areas. Western states like the US, Canada, Australia were very opposed to the ICSC initiative in this field. And now they accepted an Irish initiative which goes quite into this direction. And in my view, but this is simply my view, this was also thanks to the experience in Ukraine where these weapons with the artillery, because, you know, one of the most inhumane weapons is artillery, it's not aerial bombardments. Okay. Now, sorry, it was very important, your second point, but now I forgot it. Just a key word.
What would you add to that?
Yeah. No, because he is obviously right that somehow the existing rules are quite good. Although I think the weakest is on humanitarian access and assistance. Because under the existing rules, you need the consent of the state. Also, the Security Council has declared, and we all believe that this cannot be denied arbitrarily, but nevertheless, here we have a real problem. And also, in relation with sieges, you know, Aleppo, Mariupol, and so on, the rules are not sufficient because the one who besieges, so the government forces in Aleppo, under existing IHL, they can say, okay, we let food in, but we have to have a guarantee that this food is distributed only to civilians. And you will never get this guarantee. And you will never get a situation where the people in Aleppo, the fighters, are starving and the civilians have food. So there we would need new rules. But overall, and I think it would be important that you do not remain with the impression, Sassòli has told us, that IHL is not appropriate for today's armed conflict. But obviously, and then also the law of non-international armed conflict, there is a problem in the relationship with domestic law and human rights law, because it was made at the time thinking about civil wars. And there, a lot of rules, you don't need them because you have domestic law. But if, for instance, the United States or Saudi Arabia fight in another state, they cannot apply their domestic law. And they have also, there are tricky legal problems to apply the domestic law of the country where they are fighting. And here we have lacunas in the law of non-international armed conflict, which would deserve to be filled in. But as I said, there's no chance presently to, I would not recommend the ICSC or Switzerland to invite to a diplomatic conference. It would rather probably weaken IHL if today there was a discussion between states to update the rules.
Thank you, Doctor. Dr. Mu'taz, and then we will go to, please.
Thanks, Professor Marco. I have two questions, comment and questions. The first comment regarding principle of reciprocity and its role in the development of international humanitarian law. This is the logic of international humanitarian law, that warring party will consider these rules in order to achieve reciprocity and to benefit, all of them to benefit from that. But what we are seeing, it is not the reality. The reality is that attacking civilians, terrorizing civilians has become part of the conflict tactics. And this is what we are seeing in the Middle East. You are talking about Sudan attacking civilians in Darfur was part of the regime to terrorize the rebels and also to stop the rebels. At the same time in Syria, the same happened with the Russian intervention. So what we need in this regard is to have actors outside beyond the warring party to enforce the rules, the rule of high contracting parties, but today also they export weapons to the warring party, and this is also the reality that we have seen in the Middle East, that international actors who are working to settle this conflict, they are the same actors who provide weapons to the warring parties. Justice and accountability is also another way, but it is politicized in international community. So this is the dilemma, the reciprocity principle in theory could work, but it does not, because attacking civilians has become a way to win the conflict. My second question, I would like to hear your views on the interaction between international human rights law and international humanitarian law in conflict setting, because this is a controversial issue and there are different approaches and trends in seeing that. So what is the position right now, and how international law developed in this area, the intersection between both branches in conflict settings? Thank you.
Before I allow to, there is a complementary question to the second part, which is, how can you say that there are only war crimes under IHL or in an armed conflict and not any human rights? So just to answer it.
Well, I couldn't have better summarized the problem than you mentioned. Now, on reciprocity, I would simply make the difference between positive and negative reciprocity, and saying positive reciprocity is if I respect the rules in the hope that the other party will also respect it, while I fully agree with you, there's no negative reciprocity in IHL, and this is clear under the treaties, that if you violate the rules, this doesn't give me the right to violate the rules. And then something I think some of your doctoral students could have a look into it, because it's not a legal problem. Is it true what you say, that some parties win the war because they attack civilians? We should make a serious analysis based on evidence whether this is true. And I'm not sure. Perhaps, I hope so, the contrary is true. That history, but obviously in the long run we are all dead. So that history shows that those who violate IHL will finally lose the war. But it might take some time and so on. Now, obviously we could make a whole lecture about IHL and human rights law. Well, I think, and this is today more or less uncontroversial, that human rights law continues to apply in armed conflict. And we have to determine the lex specialis, and in some cases it is IHL, and in some cases human rights law. On many issues, even in an armed conflict, human rights law is more precise and gives more details, and then we apply the rules which contain more details. And the actual contradictions are only in very few fields, like the use of force, lethal force is very exceptional in human rights law, and you have to try to arrest someone, while at least in an international armed conflict I can shoot on a combatant even without trying to arrest a combatant. And detention without trial. I mean, for every human rights person, the most shocking thing is if people are detained without any judicial control for an indefinite period. But this is precisely what the Third Geneva Convention foresees for prisoners of war. So this is again my pleading not to apply this by analogy to non-international armed conflict. And I think in non-international armed conflict, where there are lacunas in IHL, we should, rather than to fill them in with the law of international armed conflict, to fill them in with the law of human rights. But the big difficulty is in the so-called extraterritorial non-international armed conflict. I mean, when the Americans were fighting in Afghanistan, they would say, human rights law, we have obligations in the US, but not in Afghanistan. And on some issues, they have a point, because they cannot make legislation about how to behave in Afghanistan for the local population. It's only the Afghans who can make such legislation. So, and to your point, war crimes, yes, absolutely. There are no war crimes outside armed conflict. And this is one of the reasons why it's important to clarify whether something is an armed conflict. But obviously, even outside armed conflicts, there are crimes against humanity, and there is a possibility of genocide also. I think we shouldn't use this term too liberally. I mean, it's a very rare thing. And many people who fight for a good cause try to call this genocide. I would say keep crimes against humanity and war crimes.
So thank you very much for the informative session, and I really would like to thank the question before me, because it's somehow starts the question that I want to ask. I come from Aleppo city, the very city that was besieged in Syria, and I worked in a lot of humanitarian work in Syria. So there is to the point about being in touch with non-state actors. I think this is a very valid one. In Syria, we have a Syria legal program. They had an initiative, and they came to Syria, trained fighters under a program called Muqatil La Qatil, fighter, but not a killer. And it was very effective in raising awareness among freedom fighters against criminal Assad. But and I think Geneva Code also had some programs in Syria, and I don't know how much but I think this is a very important, needed efforts. But at the same time, we have very clearly a very proved evidence criminal attacks and criminal acts from Assad and Russia. We have the chemical attacks, we have the detention and torture of prisoners, we have, in fact, the list can go on and on. And the question is about the impunity, accountability, and maybe this is the question that's been raised before. But I just want to ask it in a more particular way. We understand that the most of the current conflicts in the current era is civil conflicts that can be categorized under civil conflicts, and it's by proxy wars, because we understand this is a by proxy wars in sometimes. So how we can improve the validity of IHL without having more about the enforcement of these IHL. And in the question here about whether the humanitarian diplomacy, which is a new ICRC tool, can play such a role in this. Thank you very much.
Let's take the second question, please, and then we give the floor to Dr. Sassòli.
Thank you, Dr. Sassòli, for the informative presentation. Actually, you mentioned an interesting point when you talked about the negotiation with the war criminals, or those who were in violations against the human rights. But this is dilemma. So, from the law of conflict perspective, particularly the non-international one. So, are there specific rules or regulations should be followed during the negotiation processes with the war criminals to avoid at least provide a kind of legitimacy to those criminals? You know, we have a lot of examples now, negotiations and many negotiations with the Syrian regime, for instance, happened. So what are the regulations should be followed from the international process, or the measures we should take in for this process? Thank you.
The lady here, if we can take the last question, if there are no burning questions from colleagues before we conclude.
Thank you. Hi, everyone. My name is Safa Jaber. I have two questions. The first question is related to the question of Dr. Mu'taz and Dr. Iyad. It's about the relationship between international humanitarian law and international human rights law. My question is, for sure you know the dilemma about Gaza Strip and whether to consider it as an occupied territory or not, because we don't have boots on the ground as a criteria for occupation. So my question here, is it better to consider Gaza Strip as an occupied territory, or is it better to apply human rights extraterritorially? So which one would provide more protection for civilians there? This is the first question, and I think it's related to my second question. You know that there is request by the UN General Assembly to the International Court of Justice to deliver advisory opinion about the Palestinian territories, occupied Palestinian territories. Do you think this advisory opinion would be different from the previous advisory opinion, the wall in 2003? Should we be optimistic about the consequences of this advisory opinion, or it would be similar to the other advisory opinion? Thank you.
Well, thank you very much for the two questions. Dr. Sassòli, give you the floor, please.
Yeah, thank you very much. Well, impunity in Syria, yes, one can become very depressed. But you know, you are certainly familiar with the triple IM in Geneva, and I have some former students who work there. But they never tell me what they are serious. I mean, some of my former students are in the ICC, and they tell me all kinds of things, what they do. Those who are in the triple IM are totally confidential. When I meet them on the road, they go on the other side of the road because they don't want to see me, because they are afraid that I ask them, how do things go, and did you have some successes, and so. But it's very serious. They prepare real criminal files on individuals. And I hope, but I didn't make a sociological inquiry in Syria, that this makes people afraid in Syria. Not Bashar al-Assad, but the lower level. And I don't know, because my students don't tell me anything. The German prosecutor who was able to prosecute some people who committed war crimes in Syria, whether he got some information from the triple IM. And now, you know, I'm never neutral, so I am also in the executive committee of the International Commission of Jurists, and we have made a proposal to have a universal mechanism like this, to draw from the experience of the Syria and Myanmar. There's also such a mechanism. And to have this mechanism also at the disposal of commissions of inquiry, to avoid that such commissions of inquiry need first 6 months to constitute and to find the staff and all these things. So there would be a permanent place, obviously, as I'm paid by the Canton of Geneva, I must suggest in Geneva, a permanent institution which is at the disposal both to make such inquiry for criminal purposes and of any human rights fact-finding body. And today all the human rights fact-finding bodies also deal with IHR. Humanitarian diplomacy is certainly one way. And I think we need both humanitarian diplomacy and serious pressure. And it was mentioned before, I mean, if you give a party weapons, you have a responsibility to make sure that these weapons are not used in violation of international humanitarian law. And there is, it was mentioned before, Article 1 common to the Geneva Conventions, which says that all the high contracting parties have an obligation not only to respect but also to ensure respect. Now, negotiations with war criminals, that's a difficult thing. My illusion is that it should still be possible to separate political issues and humanitarian issues, and to tell the war criminals, I cannot speak about political issues, but there are serious arguments, and this is what, for instance, the US Supreme Court said in the case Holder against Humanitarian Law Project. They say, even if you disseminate IHL to them, you give them some legitimacy, and therefore this is support to terrorism. And here I would simply make a policy decision to say, yes, but it is more important to give assistance to the civilian population or to try to get the respect of IHL than this legitimacy. And you know, Geneva Call made a big effort in these deeds of commitment. There's always a clause which says, like in Article 3 common of the Geneva Convention, that this doesn't change the legal status of the parties. And they sign that. Implicitly, obviously, those of you who are in political science will say, this is the typical illusion of a lawyer. He thinks because it's written there, it will not give legitimacy. And a lot of these groups, indeed, when they come to Geneva to sign such a deed of commitment, somehow they no longer feel as criminals, but are serious people who sign in Geneva, and then they go back in the desert or in the mountains in Kurdistan, and they say, now, we have to deliver, because I signed in Geneva in the Alabama room, so I'm a serious leader, and now I need to deliver. Okay, so the rules to be followed, I mean, I have some friends who are specialized in humanitarian negotiation. Claude Brudalin, you must know him. There's a center also in Geneva, which deals precisely with such issues of humanitarian negotiations, where there's the dilemma not to be, you know, I don't know who remembers the so-called Stockholm Syndrome. The Stockholm Syndrome is that you get taken as a hostage, and finally you get sympathetic to the hostage takers because you discussed for such a long time. And when I was chairing the board of Geneva Call, I always cautioned my colleagues to say, let's avoid the Stockholm Syndrome. I would prefer a world without armed groups, but armed groups are a reality, and we have to live with this reality. But we shouldn't suddenly get too sympathetic to them. They are part of the problem, but armies are also part of the problem, and we have to deal with them. And when Henri Dunant came to Solferino, he didn't consider, I'm sure he didn't consider, that this war between Napoleon and the Austrians was a good idea, but he simply said, okay, this is the reality, let's try to find some solutions. But I'm conscious that especially today, with the tendency to have an integrated approach and so on, it can be dangerous. So we have to be careful. Now, the Gaza Strip, I don't think the main problem, the main problem is whether we apply human rights law and humanitarian law, because both. But simply the advantage of humanitarian law is there's no controversy about extraterritorial application, while several states like Israel, the US, but also Russia, they say there's no extraterritorial application. And then the majority opinion is that the Gaza Strip is fully occupied. I would have a functional approach to say simply, in those fields, and there are many fields in which Israel still has control, it has to comply with the law of occupation. But on other issues where Israel has no control, like the maintenance of public order in Gaza, this is an issue for Hamas and is a human rights issue. And finally, the ICJ advisory opinion, I think it's quite a different issue now, and I'm happy about that. Hopefully it will be understood, but I count on all these international law specialists that they understand it. Because last time it was mainly an IHL issue. Now it's not an IHL issue. Now the issue is, must Israel withdraw from the occupied territories? Because occupation cannot be 70 years. I mean, the law of occupation was made for a short time, 4 years, 5 years, something like that. And, but I would say, let's not abandon the law of occupation. Let's have the law of occupation, but at the same time, I think the law of occupation, as all of humanitarian law, cannot be an alibi to continue the war. I mean, Henri Dunant in Solferino, he didn't consider that if we treat the wounded, this is a justification to continue the war. No. And this is the basic idea of all those in the Red Crescent, in the Red Cross, that we help people, and it is not because we help people that we prolong the war. And therefore, the fact that the law of occupation applies should not be an alibi to deny the Palestinian people the right to self-determination, which is not an IHL issue, but a human rights issue. And there I agree with you. There we need human rights. And here it is clear that it applies extraterritorially, because you cannot deny the right to self-determination to people over whom to whom you deny it, and the Palestinian people, especially in the West Bank, they are clearly under control of Israel. Thank you.
Well, Dr. Marco, thank you very much for the answers and for the interaction with the audience. This has been a very, very beautiful journey, going through it from start to it. No, but it gives us also the perspective and the reality. Sometimes reality has to be here. And with concluding this discussion, I would like to refer back to the organizers, thanking Dr. Ghassan and Dr. Mu'taz for their speeches announcing the start of this presentation and lecture, and would like also to conclude with our co-organizer of this event, the Qatari Red Crescent Society, by giving the floor to Mr. Faisal to give us his closing speech. So we'll be delighted. Mr. Faisal, please.
May God's peace be upon you. In conclusion, I would like to offer you my appreciation for your interaction, and I would like to express our deepest appreciation for Professor Marco Sassòli, who's the most important distinctive expert in international law, for sharing his expertise in this session that was organized by Center of Conflict and Humanitarian Work and the Doha Institutes in cooperation with the Qatar Red Crescent under the title of International Humanitarian Law Between Theory and Practice in Light of Armed Conflicts. The victims of wars around the world remind us every day that protecting the most vulnerable ones and ending the humanitarian suffering is a common joint responsibilities for cooperation as a humanitarian organization and research centers and academic centers to brainstorm about the mechanisms that enable us to face challenges that we are witnessing in implementing the international humanitarian law, especially taking into consideration the current affairs and what the long armed conflicts result of the destruction of lives of refugees and the IDPs. We, the Qatar Red Crescent, we believe that the importance of IHL and the importance of respecting it and taking into consideration the changing mode of armed conflicts. Our message for the whole world is there's a need, the need for protecting civilians is more urgent than any other time. Thank you so much, and may God's peace and blessings be upon you. In conclusion, we'd like to thank you all. شكرا جزيلا لحضوركم معنا اليوم. شكرا.